Okay, so yeah, welcome, and again, we'll probably see some people joining us in the next minute or two, but we'll kick off today's session. Today's masterclass, and it's our first masterclass in the series, is about how to raise your awareness of effectively managing data subject access requests, which I know that all of our clients struggle with and deal with on an increasingly regular basis, and the level of complexity seems to increase as well. So, the idea of our masterclass concept and why we're doing this, and this is purely for clients of our data protection services. It's not open to the public or non-clients. It's just for you. And it's for kind of three core reasons. So we're looking to enhance the ongoing support you already receive from us as clients of our team. Also to drill down into some common data protection challenges and issues that you might regularly deal with. So these are the kinds of topics and issues that we support clients with on an almost daily basis or on a very, very regular basis, and to provide you with some more granular awareness of those issues. So not to replace the support that we provide to you as data protection officers and advisors, but to add that sort of raised awareness so that you can deal with these issues um, on the ground and in the moment, and in maybe in a more informed way, independently as well, which can only be good. So essentially, what we're looking to do here is to add value to the existing support that we provide to you, help you to make better in the moment decisions, and to ultimately reduce your risks of non-compliance and to improve your practice and best practice in relation to data protection. And as I said, these sessions are just for clients of our team. So we're really happy to be able to provide this new concept. Today's session, for those of you that might have attended previous webinars that we've run in the past, these faces and names will be very familiar to you. I'm your host, Rich Jackson, today, and then we have two vastly experienced data protection officers that will lead the session. So Megan and Ian, if you could introduce yourselves, so I'm sure that people know you, but it'd be great to have a brief intro.
Sure. I'm Megan Mercer. I'm a data protection officer within the team. I've been here for about 4 years. Prior to that, I was in central government working in the data protection team in the Ministry of Justice, and before that at the Information Commissioner's Office for just over 10 years. So clearly I started working in data protection when I was a child. And over to you, Ian.
Yeah, so very similar. I've been here for about 1 year or just coming up to 1 year. Prior to this, I was sort of head of a privacy function for a sort of multinational group of um, private companies. And then prior to that, actually worked with Megan at the Information Commissioner's Office also for roughly 10 years before sort of heading out into private sector. So again, been in the data protection game for a long time, shall we say.
Brilliant. Thanks both. So today's schedule, we're gonna run through briefly a bit of a sort of DSAR 101, what are subject access requests and what is the right of access, before going into more detail in relation to the time frame of subject access and assessing the complexity. And we know that that complexity is increasing. Questions around verifying identity, if you need to do that as part of a subject access request, reasonable and proportionate searches, what to do if you feel that you need to refuse a request. And then we have some really good recent case studies and recent examples of ICO enforcement action and reprimands and financial penalties, which I think bring all of this to life. And I think there's nothing better than a good case study to do that. Today's session is being recorded. You will have a chance to ask questions at the end, but all of the slides and a recording of the session will be shared with all of our clients after the event as well. So a bit of that, bit of a run through subject access and a bit of a 101, as we say. Ian, would you be able to just give us a very sort of brief overview of what rights are in relation to
Yeah,
legislation? Yeah.
yeah. So there's obviously, you know, multiple rights available to individuals under data protection law. Obviously, we're focusing on the right of access today, so we're not going to be talking about all the other ones in the list that we haven't highlighted. But I think, one of the things that it's worth pointing out here is that whilst there are numerous rights available to individuals, all related to managing, the effective use of their personal information, you're going to hear us talk on a number of occasions today about the sort of fundamental importance of the right of access. And so to pick it out from amongst the other rights is important because it's sort of the gateway right. Because by getting access to your personal information, you're able to identify issues with it. So, for example, how do you know it's inaccurate, and therefore, how do you know to exercise your right of rectification if you can't even get access to your personal data in the first place, right? So, it does have a particularly special place, I think, within the list of rights available to individuals. And we're going to be calling on that today quite a lot, that what we call the fundamental nature of the right of access. And that's basically what we mean, that yes, it is one amongst many, but it's quite a special one amongst many.
Thanks, Ian. Yeah, and I guess this slide kind of sums it up in more detail in what it actually means.
And I guess it's just adding on to that to say it's a right of access to your personal data. It is not a right of access to documents. So it's distinguishing between the two because that's quite a different thing. So often when people get a response to their request, they will just get one document that contains their own personal data without actual documents being attached to that response. So it is only their personal data that they're entitled to request. We will talk about exemptions, but it's not the actual documents. They can't just reel off a list of documents that they want from you. They are only entitled to receive the information within the document that relates to them.
Yeah, I guess as well, touching on both your sort of points there on the right of access, is it fair to say that this is the right that people are by far most aware of, and the right that they are exercising and aware that obviously they exercise it because they're aware of it, but does it sort of stand out in that sense?
I think so. Yeah, I think it's definitely, I think in my experience, it's the one that people exercise the most, you
I
know.
think, yeah,
And that shows you just how important it can be, because why do people exercise it? Well, I mean, maybe the more cynical people might say because they've got an axe to grind, and interestingly, we might talk about that a little bit later on, but
Yeah.
they access it because they exercise it because they want to see what's been said about them. They want to see what you hold about them. They want to know what's going on. It's often about trying to understand decisions that have been made, for example.
Yeah.
So it is by far, in my experience, the one that's exercised the most, for sure.
Yeah. And data, I think, always, excuse me, brings all of these subjects to life. So I think from our experience, it seems like particularly from the beginning of last year, I know that Megan and I sort of when we were working before Ian joined the team, I think it was April, wasn't it, Ian, or March or April?
Mhm.
Um, we suddenly saw a spike at the beginning of 2025 in our clients needing support with DSARs. We noted that organizations and clients and a lot of noise in the media amongst other data protection professionals was that organizations were struggling to manage this, the real life operational impact, the fact that it takes so much time to deal with these things alongside the day job in inverted commas, and suddenly became a resource heavy task. 40 to 50% of all complaints made to the ICO relate to subject access. And we know that, and these stats can vary, but they can be costly as well. So 70% plus of subject access requests incur an operational overhead of £3,000 plus. So just the time to spend doing it, the reallocation of your resources in your team, maybe involving external organizations to help you achieve what you need to get the DSAR over the line. It all adds a cost in many ways. And we were debating, or not debating, I was rightly corrected on a number. So I guessed and I assumed that we were still around sort of 15 to 20,000 complaints annually to the ICO about subject access. It's actually over 40,000 last year. So, and that increase, I think, Megan, is, you commented on the figures the 2 years before that. There is a constant steady increase, isn't there, in those numbers?
absolutely. And they've got significant backlogs at the moment in terms of looking at those complaints because there are so many. So
Yeah.
they are going through the roof. So organizations that have never had one before are starting to get them now. And it's you're absolutely right in terms of the resource implications for it, but it's also the emotional impact as well, because often these are from members of staff, and it's there's a lot of work that goes into looking at and reviewing the information, and other people are often drawn into that, and it does become quite a tricky thing to manage. And also that's just one SAR coming into the organization. If you start getting more and more coming in, you've got three at one time to try and manage, then it starts becoming very resource intensive and difficult to manage. So, some of the bigger organizations are getting up to 30 SARs a month. So it varies depending on the nature of the data that the organization processes.
Yeah, and I guess that's where it changes from being an occasional instance that you deal with. You don't get many, but when you do, you kind of work around it to it being a systemic issue that you need to actually resource and dedicate resources to, doesn't it?
Yeah.
Yeah, and as we'll see in the case studies, multiple public and private sector organizations have been reprimanded or fined in relation to subject access, and particularly within the statutory timescale. Privacy Engine has done some good research here, and I think this would probably match with what we see in our experience working with clients that, as Megan said, a lot of this stuff is coming from employees. It's actually 66% according to that research. I think it would be easy to assume that it would just be the public or customers that people you would think the most of this stuff comes from. It doesn't. It is coming from people that you know and work with on a regular basis. And in the other section, the 19%, that would that would include people who are ex-employees as well. So there's, as Megan said, the emotional side of this and the familiarity with the people that are submitting the requests, and the reasons for that, for the requests. Rarely because they're happy or satisfied with someone submit a subject access request. Nearly always hoping that they'll get some insights into specific issues or circumstances that they want to find out more about. And I think they're becoming increasingly complex and more regular. And typically, subject access requests are resource intensive, stressful, costly, complex, and rarely straightforward. I think that's quite a hard hitting slide in some ways, but I think that probably reflects the
Yeah, and I
state of
think
things, doesn't it?
Yeah, and I think the way they word it as well is becoming more complex as well. They're
Mm.
very legalistic the way the requests are being written now, often probably used with AI generating those requests. So they're very particular, referring to articles in the legislation and quite specific about what they're actually asking for. So metadata, that type of stuff. You get a long list of what these individuals are after. So that's quite scary when an organization receives that type of legalistically written letter,
Yeah.
or email or whatever it might be.
Yeah. Worth adding, isn't it, that doesn't that we are seeing that on a regular basis and it is intimidating, but that a request in that form doesn't carry any more weight than someone
No,
just asking, can I have my data?
or
So
someone just ringing up and saying, can you
yeah.
send me my data? Yeah,
Yeah. But
absolutely.
receiving it is definitely intimidating. Yeah.
Yeah.
Yeah, so so that's the kind of the 101 and that sort of overview of subject access requests and the impact of them. So at this point, we'll kind of go into more granular detail on certain subjects. So we'll start off with extending the time frame, which is a question we get asked consistently from our clients in terms of they feel that a month, the calendar month, isn't long enough for them to achieve putting all of this together. Um, in some instances, our view is that they can extend it more often than not. I think they probably are not able to for the reasons I think that Megan and Ian will explain.
Yeah, so the response, you have 1 month to respond to a subject access request, and that starts on the day that you receive the request, unless you need to check ID or where you might be seeking clarification to help you find the personal data that individual has asked for. But just your bog standard SAR response is 1 month in terms of the timescale. But there are certain circumstances where you can increase that response time by a further 2 months. And this is where it's complex or where you've received multiple requests from the same person, which I guess links into the fact that it becomes complex for that reason. It's quite a high bar to meet in terms of applying that extension. So for something to be complex, an example of that could be that you need to seek legal advice, or there might be some potential employment tribunal issues going on in the background, something along those lines. There could be a lot of information contained with that, but that doesn't, just having a lot of personal data doesn't justify the complex application. So bad records management doesn't justify extending that request. So it's very case by case, but you need to look at it in the round in terms of who is the requester, what are they asking for, what's actually going on, what's the context, and you may be able to apply that that extension of time of the further 2 months. You don't necessarily have to apply 2 months. You could just say we need an additional month, for example, but you do need to let that individual know before that 1 month timescale is gone that you are extending the timescale for responding. And that's really important in terms of keeping them up to date with what's happening with their request. Ian,
Yeah.
did you want to add anything else on that in terms of complexity in applying?
And I don't think so, but I think it's worth reiterating that point about poor records management and things like that not being grounds for doing it, because I think that's something that we're going to be revisiting a number of times over the course of this session, because it's relevant to other things as well. That you are expected to have, data protection by design and default, to have systems in place to help you do these things. And so therefore saying, well, we don't, and therefore it's too hard, is not likely to ultimately enable you to do that. And I suppose the other thing that we would probably say as well is, and this is something else that's probably going to come up a lot over this session, is definitely worth contacting, your appointed DPO and getting some advice from them if you are thinking of wanting to apply for an extension or something like that, so that we can give you proper advice around, whether we think it'll stick and, whether you've considered the right things and things like that.
Yeah. I guess more often than not, when we're working with clients on this very subject, their reasons for asking if we think they can apply the extension are typically around the volume of work that it relates to, and how long it's going to take, as opposed to whether it really is complex, etc. And I think that's a fairly common conversation with our clients, isn't it?
Yes, it
That's,
is, definitely.
yeah, I suppose another thing that's just sort of popped in. I was looking when I was looking into this the other day, is you have got certain limited grounds where if you're applying exemptions, you might be able to apply for an extension. But even then, it's dependent on the nature of the information you're applying them to and how much of the information you've got and things like that. So, as with all these things, a lot of the things we're going to talk about today, I suppose, hence the title Masterclass, they're not the simplest aspects of subject access requests. They're some of the more technical ones, and they require a degree of judgment to be made, I think.
Yeah, absolutely. Yeah, so in terms of assessing the complexity, again, this is the idea of today's masterclass is to go into more detail, as Ian said, but also to remember that we're not trying to replicate the fact that we're here for you to advise on all of these issues.
And what might appear complex at the start or as the request comes in. So, for example, you might say you've had an employee that's worked with you for 10 years. We're going to have thousands and thousands of emails. That then links into perhaps getting clarity or clarification from the individual in terms of what are they actually after. They don't necessarily have to narrow it down, but if they do, that's helpful. But it's also, we will be talking about reasonable and proportionate searches. It can be possible to make it less complex by narrowing down who you are asking for internally, who might hold information about that individual. So it does link into that, but it's really just being mindful of the fact that you can't just say, oh, this is complex and apply an extra 2 months and just have a 3 month response time. It just doesn't, as I said, it's a very high bar to meet in terms of justifying the complexity, but completely justified if you have those reasons to do so, and you should do so. Just to say, though, those 3 months actually go really quick as well. So you need to
Yeah,
get onto it straight away.
Yeah, I think it's it's that thing that comes up a lot, isn't it? There's a big difference between this is hard work and this is complex. Hard work does not equal complex. There are specific things you have to factor in when deciding whether it's complex or not. So,
Yeah, I mean, from my experience as well, and this is probably the same for us all. A lot of this, a lot of the how well a DSAR goes is very much dependent on how it's managed right from the outset, in terms of
Yeah.
how quickly you pick up the request has even been made, how much time is lost in kind of deciding what to do next, and that then immediately adds pressure on that initial calendar month. As Megan said, 3 months flies by, but that first calendar month, if you lose 10 days to 2 weeks before you even get into it, that immediately ramps up the pressure. And we've all mentioned already the importance of communicating and providing updates to the applicant. That can also make a massive difference to how well
Yeah.
this process goes.
I think as well that sort of ties into another point worth making, and again, it's relevant to everything we're going to talk about today, which is you may, you may have a month, you may think you've got 3 months, but if you wait a month and then tell them it's complex and you want another 2 months, then the ICO is not going to let that wash either. These responses have to be made promptly as soon as possible, whatever phrase you want to make. That includes writing to people to let them know that you think that this is complex and will require. Now, obviously, there'll be a degree of time allowed to assess the complexity and of all the things we just talked about, but that's not going to extend to, well, we sat on it for a month and then we wrote to them and said, oh, actually, we need another two. So you've got to be prompt in terms of getting out to people, and those updates, like you said, Rich, about keeping people informed about what's going on, really important, I think.
Yeah, it's quite common, isn't it, to get for clients and organizations to maybe get week 3 of that calendar month and to then think we're not going to get this done. And that's when they start to think about extensions. Can we buy some time? And going back to the points Ian's just made, that's not going to wash. You have to, and this is where a good process comes into play. When you receive a subject access request, you know pretty closely how long it's going to take you to do it and what's involved, how complex is it.
You
Rather
almost
than,
want to do like an initial triage view of
yeah,
it and
yeah,
say, okay, what are they asking for? Do we think there are obvious reasons why this is going to be complex? And if there is, then you can get that notification out to them, fairly quickly.
yeah.
Or it might be that you can provide the stuff that isn't complex within that first 3 weeks, but then alongside that, you might write to them at the same time and say, but the rest of it we think is complex because we've got to get legal advice or because we're assessing issues around confidentiality or whatever it may be, and therefore for this we're going to require another 2 months, or so as with all these things, it may vary from case to case, but the expectation will be that you have informed them as quickly as you reasonably could have about the need for an extension and why. And if the ICO is of the view that actually you haven't done that and you're just using it as a delaying tactic, then they're not going to let that wash.
No, not at all. Yeah. And as with everything we cover today, we're here to advise when you
Absolutely.
need us. Verifying identity. Again, when we picked these sort of headlines today, we got together as a team and thought, what are the most common issues that we support clients with and get asked about? This is one, about whether there's a need to verify identity.
So the risk is that you disclose a load of personal data to someone who isn't actually who they say they are. And that could be really sensitive HR related information. It could be anything, but that would technically be a breach under the legislation as well, because you've disclosed it to someone that shouldn't have had that information. So it is really important that you're assured or confident that the person that's requesting the information is who they say they are. So how do you do that? So if it's a current employee, they might make the request through their own internal email address, so you know for sure that that is who they say they are. If it's external, you might have something that you can use to identify them. So it might be some code or invoice reference number or something along those lines. But in some cases, you will have to check ID, and that may be that you need to ask them to prove who they say they are. So that could be a driving license, for example. You would then check the ID, verify yourself that it is who they say they are. You might want to check other communications you've had with them and whether it's the same email address, for example, but you need to be absolutely confident that you are disclosing it to the right individual. In terms of checking ID, you might take a copy of the driving license, or they may send you a copy of it. You should only be using that for the purpose of identifying the individual and then delete it after that, so you're not holding irrelevant data that you don't need. But it is really important. I really can't emphasize enough how important it is to know who you are disclosing that personal data to. I've dealt with something recently where something was sent out to a requester, ID checks weren't done, and I must say I'm not 100% confident it was the right person to receive that information. But so it is important that you do double check that before you even start thinking about dealing with the request, because that
Yeah.
then links into refusing the request if you can't identify that person.
Yeah. And we would, we would potentially be working with clients who that information going to the wrong person could potentially put someone at risk of harm and put them in
Absolutely.
danger. Yeah,
Well,
absolutely.
it ties into the sort of nature of the information you're disclosing as well to a certain extent, doesn't it? The more sensitive it is,
Yeah.
the more important it is that you're satisfied that you're sending it to the right person, because as you've just said, Rich, if it's not, then the risk of harm is greater, and the severity of that, well, it'd effectively be a personal data breach at that point, wouldn't it?
Yeah.
The severity of that breach would be greater. So
Yeah.
Yeah, I think, I mean, so with the panel question that's come up on the screen, so I think that there have been instances, I think, where organizations might routinely rely on asking for ID just to buy time. Is that fair? And that's obviously not an appropriate use of this process. So what factors should be considered when deciding whether it's appropriate? I mean, Megan, you've touched on this already, I guess.
Yeah. And also we've got examples where organizations require too much in terms of
Mm,
ID. So there was a case quite a few years ago now where an organization was asking individuals to provide two forms of ID plus a statutory declaration from a justice of the peace to say they were who they say they were, completely over the top. So I think you've touched on it really. It's looking at the information that you are going to disclose and whether you're confident that you have verified sufficiently their ID. So as I said, I've given you some examples of where you might do that. But generally speaking, if you are unsure, you need to ask for example, a driving license or something like that, so they can verify who they are, they are who they say they are, but maybe linking
yeah,
into other information you have on your system, which might be their email address as well.
yeah,
yeah,
I was going to say, I was just going to add to that. I think, you sort of look at the request in the round, right? So where has it come from? Has it come from an email address that you recognize?
Yeah.
To go to that point about other information, have they supplied you with other information? Like, a lot of this is stuff Megan's touched on, the reference number, your bank account details, your whatever it may be. Because if it comes from an email address you recognize and they've given you all their account details and things like that, is it reasonable to request ID versus it's come from an email address that you've not got on file for this individual, and it's given you no details about, they've not given you their account details or any kind of reference numbers and things like that. Obviously, it's more reasonable in that situation, I would say, to then ask for proof of ID than it would be in the other. But there's always that question of what information are you supplying, how much of it, and what's the risk if you get it wrong.
yeah,
I
yeah,
should say that
absolutely.
if you are going to request ID, the clock stops. So it doesn't start again until they've provided that ID to you. So they generally tend to turn it around quite quickly, so the clock doesn't stop for long.
Mm.
But it does stop until you've verified or reassured yourselves that that is who they say they are in terms of making the request.
Yeah, we were discussing this a couple of days ago. I think I recall, Ian, and you were talking about this in the fact that some organizations then make the mistake of stopping altogether themselves and stop actually working on the subject access request, and that's valuable time lost.
Yeah, because I think, yeah, well, it goes to that point we were just making, wasn't it? That a month isn't that long,
Mm.
Mm.
So, and you don't always get three. In fact, three is really the exception rather than the rule. So you've got a month. You might have a lot of information to go through, and if you're just sitting around for the time period where you've asked for ID and they've not come back to you, and you're not taking steps to, given that we know from experience that people who make SARs are often quite motivated in terms of following through on those SARs. It's rare that they just drop off the radar if you go back to them. I would be making use of that time to start your searches, to start pulling information together and collating it into one location, because in theory, that's the quickest bit. The hardest bit is then going through all that information to look up whether you want to withhold any, whether you need to redact any, etc. And if you haven't even started by the time the ID comes in, then you could be really up against it in terms of the time frame.
Yeah, absolutely. So, yeah, things to consider. Sort of we probably touched on it in some elements, but yeah, what are the key sort of things that organizations should consider at this point?
I think we're probably, yeah, we have covered it. It's look at what information you already hold about that individual, make a decision on what type of ID you're going to ask for from those individuals in terms of reassuring yourselves. And then if you do have a copy of whatever it might be, passport or driving license, that you're not holding it. You're literally doing the check and then making a note of the fact that you've checked ID, but you don't necessarily need to keep that ID on your systems. Yeah, so it's not it's case by case as with everything with data protection.
Yeah. So next on our sort of regular topics is reasonable and proportionate searches, and I think we have instances fairly regularly where organizations actually go way further than they need to, and then incur a significant overhead that then and again tying into the timelines it just adds massive pressure unnecessarily. So I think this is a really important subject.
Mm.
Yeah, and a lot of people might think, oh, this is new. It's just come in through the Data Use and Access Act, but actually, it's not new. This has been in case law for years. In fact, I remember, I think I was at the ICO when the original case came out, and I think the High Court said something like, data controllers must take reasonable and proportionate searches, but they're not required to leave no stone unturned, I think is the quote
Yeah,
from the court
yeah.
judgment. And all the Data Use and Access Act really does is put that idea on a statutory footing, right? So in a lot of ways, this isn't new, but it's new that it's in the law explicitly. It does have close links with clarifying the request, because obviously if someone comes to you with a really well scoped, really defined request, then the fact that the idea that you might try and argue then that, well, it wouldn't be reasonable and proportionate for us to go and find this really specific information is harder to make, not impossible, when you start to look at some of the things that we've got listed below. But I think it's harder to make, right? Whereas if someone says, I want everything you hold about me, which you may then seek to clarify, but if they don't clarify and say, no, I want everything you hold on me, well, you know, is it reasonable and proportionate to have to go and search every single conceivable system that you have as an organization? Well, it's probably easier to argue that it isn't. But as with a lot of things, it's not as simple as that in practice, right? So if you see there, I've pulled together the 4 things on the slide that the ICO has sort of called out in their sort of updated subject access guidance on this. And to me, although volume of information, and although circumstances of the request perhaps could go on either side of this argument. I've said, well, actually, the circumstances of the request and the fundamental nature of the right of access. Remember, we talked about that earlier, right? They almost sit on the things that might go in favor of the individual side of the argument, right? Whereas the volume of information and the difficulties in finding it are things that an organization might say, well, these are the impacts on us and why we think it's not reasonable and proportionate. But what do they actually mean? Well, the top one's quite simple. What is the context in which the request has been made? Something that might be seen as maybe a more spurious request, although we might also be straying into, manifestly unfounded or excessive there as well. Versus a situation where there might be some legitimate importance, to the individual getting access to the information. If I think about the circumstances where most requests are received, especially when we talk about the fact that they often come from employees and former employees, they're usually made as part of some kind of dispute. So I would probably argue that in most cases, the circumstances of the request would lean in favor of the individual getting access to the information. That may not be solely determinative as to whether the searches are reasonable and proportionate, but if you're thinking about this as a sort of imaginative weighing exercise with a set of scales in your head, you've got the fundamental right of access, which just puts some automatic weight in favor of disclosure on the side of the requester. And then most of the time, not all the time, but most of the time, I would argue if the request is being made in a situation where access to the information is important to the individual, that then would also be more likely to go in favor of saying, well, you should be going and looking for that information.
Yeah. In those instances, and we see these, don't we, quite regularly, is it more likely that the requester is satisfied not to necessarily get everything you hold on me, but they're looking specifically for particular information in a particular time frame? So they're more likely to be clarifying that?
This is why I think circumstances of the request is quite interesting, because if I've just been made redundant as an employee, or if I'm going through a disciplinary or a grievance, and that's when SARs come about, I'm probably more interested in personal data about me relating to that process than I am about some random emails from 10 years ago. Not that you should have emails for 10 years, and we'll come to that probably in a minute. But you can see what I'm saying.
Yeah.
So and oftentimes, what is going to, yes, there are some individuals that will always go to the ICO and complain, but fundamentally, if the request is made in the context of a particular issue, then you should really be looking for information related to that issue, because that's probably what's driving the request. Obviously, if they've asked for everything, then you still need to go broader than that. But it's a question of what is the individual really looking for, probably that sort of stuff.
It is difficult because what we find is that IT teams will, for example, do a wash or a search across a keyword search across all systems and emails and all the rest of it. You end up getting 50,000 emails back. So I always advise that you have to initially narrow it down to who is most likely to hold personal data about this individual and then focus on that rather than doing a whole wash across every system,
Uh,
that exists.
and that's completely relevant again to the circumstances of the
Yeah,
request and another criteria that I think would be quite useful, which is the nature of your relationship with the data subject.
yeah,
All of those and everything that you've just said, Megan, links into that idea of, well, if this request has been made in the context of a disciplinary or a grievance, who were the HR team members that were involved? Who was the
yeah,
investigating
yeah,
manager? Who was this individual's line manager? You can start to pull together more tailored searches because interesting. I mean, email is a massive one in that sense, isn't it? And
yeah,
I'm going to talk about it in a little bit of detail on probably the next slide. But so circumstances of request, nature of the relationship to the individual, and tailoring your searches around that can help to make it easier.
yeah,
But what do we say about what might go on the other side of the argument? Well, obviously, volume of information and what we've got difficulty in finding it. So volume of information is not a get out of jail free card. And interestingly, the ICO guidance has an example, I think, where it references 2,000 emails being pulled back and, spoilers, but the end of that example does not say, therefore, you don't have to provide any of them, but what it does do is give you some practical advice around like what you've just said, Megan, for example, if something is just a calendar invite, if there are out of those 2,000 emails, if 500 of them are calendar invites where the only thing that was in this was the individual's name and email address. Don't pull out 500 copies of the just say somewhere we hold your name and email address in relation to calendar invites, right? And that immediately shaves 500 emails off the search function. It does go on to say that if there are emails, as there probably would be if we're sticking with the context of a disciplinary or a grievance, that go into more detail and contain more detailed personal information about the requester, then you may need to pull those emails out and redact them if necessary, and provide the information that's their personal data. So volume of information is one consideration, but clearly from the ICO's guidance, we can see that that is quite a high bar as well. And there's obviously considerations around records retention that we'll come to on the next slide. And then difficulties finding or accessing it, I think, is really about it leans into this idea of, well, if information is in systems where you might require specialist technical expertise to retrieve it, or if you have effectively deleted it, which the ICO certainly used to say means basically put it beyond use and you have no reasonable uh, intentions of using it again, then there's not an expectation. It would be easier to argue that it's not proportionate to have to dig that information back out or restore it to your systems in order to provide it. So, and I think that's probably a stronger argument, especially if it's in conjunction with there being a lot of that kind of information to say, actually, it probably wouldn't be reasonable and proportionate for us to do this. But
yeah.
well, it's probably worth actually moving on to the next slide now, Rich, I think.
Yeah, yeah, definitely. I was just going to say this. I mean, everything we've said on this slide just it rings to the fact that there's pros and cons of DSARs. The more DSARs you manage, the better you become at managing them, and the more effective all of these processes become. But that means you're getting lots of DSARs, which is a pain. But if you don't get them, and we have clients that have said to us, we've never had one, that's great. But we know that the first one they get is going to be challenging, and they
yeah,
haven't done it before, and all of these things become really difficult.
yeah,
So obviously we've I put that top bullet point on this slide because I think people often look at volume of data. As soon as you pull that one up, they hone in on it and they're like, that's the silver bullet. That is, we don't have to do it because like we've said, maybe there's 5,000 emails have come back in response to a search. Not strictly true. And really, what I wanted to talk about on this slide, rather than just sort of like restating the points, because we've talked around those a little bit, is that you have to bear in mind things like accountability, things like data protection by design and default when you're looking at this kind of stuff. Because as we said earlier, and it's particularly relevant here, if you have poorly structured file systems, if you do not have good naming conventions in place, if you don't have proper retention policies in place, if the reason why you have 10,000 emails is because your email retention policy is that you don't have one, or that you're keeping everything for 10, 15, 20 years, then the ICO is not going to accept the argument that it's not reasonable and proportionate for you to search those systems, because essentially you are the one that's at fault. You have not complied with your obligations under a privacy by design and default. If you haven't trained staff properly how to handle SARs, if you don't have policies and procedures in place to facilitate handling of subject access requests, again, you're going to have failed in your accountability obligations, and you're not really going to be able to argue that these things are, um, not reasonable and proportionate. I did have a point to make around emails on this, but we've kind of already made it, because that is the system where you often find people saying, well, there's thousands of emails. Well, have you tailored your search to specific individuals, like Megan said? Have you gone through those emails and removed things that are not realistically going to have personal data about an individual in them because it's a calendar invite or whatever it may be? And you might find then that instead of 2,000 emails, you've only got 1,000 emails. Well, that's still a lot of emails, but there's an expert. Remember the fundamental right of subject access and the importance of people getting access to their personal data means that there is a high expectation put on organizations, not just to have all the technical and organizational measures in place like we just talked about, but to put the work in and to put the effort into to provide this information.
Just quickly, from a practical point of view, though, thinking about the request when it comes in and thinking about emails. So do you make the decision of getting your IT team, whether it's an internal IT team or external supplier, to wash across all your systems doing, keyword searches like on initials or name or whatever? Or do you get individuals to make manual checks within their inboxes, for example, to check whether they hold anything? I mean, that's a decision for you as an organization to make. And then you need to think about accessing inboxes of people that might be off on long-term sick or something like that, and who are likely to hold information in their inboxes as well. So it does get into another level of decision making around how do you actually search for the data. Is it manual, is it technical, and thinking about some of those issues. Are staff aware that you might go into their inboxes while they're on long-term sick, for example? That type of thing. We do get a lot of queries about that.
Yeah, I was going to say that's a subject in and of itself, isn't it? And crops up quite often, and organisations probably are not consistently aware of whether that's something they can or can't do, and then again, have they communicated that with staff? And I'd imagine there's a lot of organisations that assume they just can't do that.
Correct. That's the indication we get. Yeah.
Yeah.
I suppose as well, it's worth just not just the last point on that slide. It's the last point on it, and this applies to everything we're going to talk about, right? You've got to apply a granular approach to this as well. The ICO guidance is quite clear that whilst it may be unreasonable and or disproportionate to search one set of data, that doesn't necessarily mean it's unreasonable or disproportionate to search for all data about them. We've already talked about ways you can narrow down your search and make things easier and more proportionate to do. So, as with all things, no blanket approaches.
Which goes for refusing requests as well, because that would be really easy.
Well, yeah, indeed.
So I touched on this before, actually. If you don't get ID from someone and you can't reassure yourselves that they are who they say they are, then you can refuse the request. So that's number one. Number two, slightly more complex, it's not as straightforward, is where the request might be manifestly unfounded or excessive. So what does that actually mean? And there's a whole list of criteria around how you determine that in ICO guidance. Broadly speaking, something manifestly unfounded would be where an individual is trying to cause trouble to a certain extent. They may say something like, I'll withdraw this request if you do this, that, and the other. And we've seen those type of requests. So you can immediately say that's manifestly unfounded. They're not doing it for a legitimate purpose, and you could refuse it on that. Excessive is where they might be making numerous requests to you on the same issue. Again, I've dealt with something like that recently, where every couple of months the individual comes back and requests the same information again because they're not convinced that they've received everything they should have received. They're looking for a smoking gun. And so it gets to the point there where you're starting to look at whether it's excessive or not. So again, the bar's quite high to refuse a request outright for those on those sort of criteria, but it's something we can advise on if need be. In some cases, at the moment, it's free for someone to make a subject access request. It used to be £10 under the old legislation for those that have been around for a while. It's free now, but there are circumstances where you can charge a fee to someone making a request, which links in, I think, around the excessiveness, possibly, or a repeat request. You might, if you've provided the information before, you might charge them a fee to provide it again, that type of thing. So if they don't pay the fee, then again, you can refuse it outright. So I've not come across any cases on that where there's a fee involved and they haven't paid it, but have come across a lot where it's potentially excessive, repeat, not letting it go.
You will see the
scenarios.
occasional sort of privacy notice on the website still that says that they will charge the fee because they haven't updated since sort of 2017 or 1998 in some instances. So if an organization does feel they have grounds for refusing, what sort of steps do they need to take to make sure they do this in the right way?
I mean, essentially, it's about explaining it to the individual why they're refusing the request, and then giving them information about, the fact that they can complain to the ICO about that decision if they're unhappy with it. But beyond that, I mean, Ian, unless there's anything else you can think of, that's really the main thing, isn't it? Telling the person you're refusing it.
In simple terms, if you're going to refuse a request, you've still got to write to them and tell them that you're refusing it and why you're refusing it. I suppose that there might be an argument in some maybe edge cases where, you could still provide them with what I might call the procedural aspects of the SAR. So like, all the stuff like what data do you hold about them, who do you share it with, or you can point to your privacy notice if that's quicker, in the sense that it might be harder to argue that is excessive. Although if the request is unfounded, you might not even provide them with that. But the key point is refusing a request, you still have to write to them and tell them that A, you're refusing it, and B, why you are refusing it.
Yeah.
Sorry.
No, go on.
No, you crack on.
I was just saying the other example where you might wholly or partially, in this case, refuse a request, if that's the right term, is if you're applying exemptions. We're not going to go into any exemptions in detail today because you could easily talk for an hour even on just one of the exemptions, or I certainly could. Again, not intended for blanket application, so that's a key point to make. And it's also an interesting exception to what we've just said, because there are some exemptions where you might refuse on the basis of an exemption and tell them that you're refusing it, but not tell them why. And we'll come to that in a minute. And the main thing we want to talk about with exemptions today is just to sort of educate people that these exemptions typically exist to protect specific interests or purposes and things like that go on in society, and make sure that data protection rights like the right of access can't undermine or prejudice, as some of the exemptions say, those purposes, right? So they are structured in a very particular way. So you shouldn't look at an exemption, read its name, and say, great, well, then we can just apply that exemption to this because it says, crime and taxation or whatever it says. You have to really look at what does the exemption say, because they all are usually narrowly construed in terms of they apply to processing for certain purposes, e.g. the crime and taxation exemption that I've just mentioned, or legal and professional privilege is another one. And they typically have some kind of test in place. Now, that could be, if it's a disclosure exemption, that the disclosure is necessary for the certain purposes that it relates to. Or it could be, as is maybe a little bit more common, that applying the right in question, subject access in this case, would prejudice the purposes that are set out there. So, the key point on this slide is really just to say that exemptions are not a get out of jail free card. They are not intended for broad application, and they work in a very specific way. They're structured in a very specific way. And ultimately, again, taking into account the fundamental nature of the right of access and the fact that exemptions generally should be construed narrowly because of that, they're not necessarily as easy to apply as people might think. And as with all things that we've talked about, we would strongly advise you to come and speak to us if you would like to withhold information in response to a SAR, so that we can advise you, A, whether there is an applicable exemption, and B, how to apply that exemption.
Yeah, absolutely. And so we will, as Ian said, it's you could easily run one session on one particular exemption. But I think we are going to run a session just in a bit more detail than today. But if you could give us just a very brief example of an exemption that we come across regularly, that would be really useful.
Yeah, so well, I mean, I was going to do these the other way around, but I'm going to do I'll do the third party data one as I call it first, because I think this is one that comes up a lot when it comes to subject access requests, which is what happens if the subject access request covers documents that contain the personal information of me and someone else. Right, so you've got personal data about two individuals within the same document, and what do you do? And so that's where this exemption basically comes in. And it's an interesting one because it's actually more of a balancing exercise than it is like a prejudice test or a necessity test. Because what the Act basically says is that if you receive that request, then you shouldn't disclose personal data relating to third parties unless the individual has consented or it's basically reasonable to disclose the information without that consent. And then it gives you a range of things to consider, like, what's the type of personal data? Do you owe a duty of confidentiality to this third party individual? Have you tried to get consent and they've not been able to? And have they refused consent? But actually, it's whether it's reasonable in all the circumstances. So you could go even beyond that and think about other things. And this is why we always say people should come and seek our advice when they're applying exemptions, because they are, we could talk for an hour, 2 hours probably about how you address that balancing exercise, and it will vary greatly depending on the circumstances of each case. But it could be quite simple. For example, if you've got an email, it could just be a case of redacting email addresses and names out of signatures. It could be as simple as that, because ultimately, if you can provide someone's personal data without providing, someone else's personal data effectively, then you must do so. And that's why redaction is something that is quite a common practice when you're dealing with subject access requests, because oftentimes you just have to redact out somebody else's personal data and provide the requester's personal data.
Or you may withhold a whole document because it's mixed personal data.
Yep.
And
well, that's where it's more complicated, right?
Yeah, it is. Yeah. But to disclose it, would be risky in terms of the other information in there. It would identify someone potentially. It could be someone that's made a statement or raised a grievance about a member of staff, that type of thing. So it does become complicated in terms of when to release or when not to release, when to redact. Withholding whole documents, for example, witness statements, that type of thing. Right. Sorry, we said brief because I'm conscious of time as well.
Yeah, that's fine. And again, and everything we've covered in this particular subject, as Ian said, this is what we're here to advise on. With these sessions are not designed to offset our level of responsibility to you, and so that you go away and have to kind of research it to that extent. We're just touching on these subjects because they're highly relevant to the work that we do with you as clients, and we're here to advise you as and when. So some recent case studies. These are all available in the public domain. We've provided a bit of anonymity here and there just for the right reasons.
Personal data and all that.
All of that, yeah. I don't know who wants to sort of work us through this one to start with.
I'm happy to do this one.
Yep,
it isn't actually a really interesting one because I'm not aware of this happening before where an individual is prosecuted. And they've been prosecuted by the ICO. So the ICO does have prosecution powers, so they will take a case. So in this case, a daughter who had power of attorney for her father, who was in a care home, made a subject access request to the care home because she was concerned about the care and treatment her father was receiving or not receiving, as the case may be. The director of the care home effectively ignored the request and said he wasn't responding to it. I think there was some allegations around him actually erasing data after the request came in, concealing them and preventing disclosure of any of those records. So she complained to the ICO. He ignored or effectively put two fingers up to the ICO as well, removed the company's name from the ICO fee paying register as part of that. and they decided that it was a case where they should prosecute him. So he was a director of that company and was found guilty of intentionally obstructing a SAR. So although the fine doesn't look significant, he received a fine for just over £1,000. He was ordered to pay £5,500 costs on top of that. He has now a criminal record. And it's all out in the public domain. His name is all over the place, and it's on the ICO website as well. What it does do is highlights the fact that actually, people individually can be prosecuted in the context of the data protection legislation. There are criminal offences under the legislation. But as an organisation, you can't just ignore a subject access request coming in, because going back to Ian's point around it being a fundamental right, and the ICO clearly will take action in these types of cases. So a really interesting one in terms of that particular director. I don't think he's probably a director anymore, but he was.
Former director.
Yeah, absolutely.
Yeah, so I'll take this one, I guess. So I mean, there's been a few examples of this if you go back over sort of previous ICO enforcement action in relation to SARs. So in this case, it was a council. The council had, I'm going to call it a significant backlog, 170 SARs that were all overdue, dating back, well, what's that, 5 years? With limited progress. So you can start to see straight away that there's obviously some significant systemic issues there at this council in terms of how they are resourcing and managing that process. And also the potential impacts on individuals of not getting access to that information for so long, because they may run out of time to bring claims or various other things that, we don't know what the impact on individuals were of that. I think what's interesting here is that whereas in the last example we showed how there's almost an element of personal liability, or there can be if you commit an offence under data protection law, this is showing you one of the more commonly used ICO enforcement powers, where they take action against the organisation itself, where they issue these enforcement notices. That enforcement notice can require you to take or stop taking steps to bring your processing in compliance. So in this case, you can see there what the actions that the ICO informed the council that they had to take. Those actions themselves can lead to greater expense, because suddenly you have to do all of this within a very tight time frame, which might mean you have to bring in extra staff, or people may have to work longer, or you may have to introduce new technical systems to assist you in doing it. So I think sometimes people think that enforcement notices are sort of not as bad. But I think that oftentimes there are hidden costs associated with complying with enforcement notices that people don't think about. Not only, and of course, it's publicized and things like that. So, I think the key takeaway from this is, yes, in limited circumstances, there may be personal liability, but this is far more common, I think, in terms of the ICO taking this sort of action in relation to subject access requests. And it shows you that it's not all about fines when you don't get it quite right.
Yeah, it's fairly common, isn't it? You don't have to look too far to find lots of examples of public sector organizations such as this, that by the nature of what they do, receive high volumes of subject access requests, but typically don't have the adequate resources to do. And that's why this happens, I guess, is that sort of that perfect storm of volume and lack of resources, isn't it?
Yeah.
And non-compliance can result in contempt of court or potentially a fine on the back of it. So you could get a hit over the head a few times with different things.
Yeah, absolutely. Yeah. And our final case study.
Right.
Again,
okay.
This is very well known, I think.
Yeah, it is a well-known one. I'm not naming them, but anyway, personal data and all that. The case is an interesting one, because this is another way an individual might go through the process of trying to get some damages or make a claim in relation to a subject access request that's not gone right. So yes, of course, they can complain to the organization itself, they can complain to the ICO, but they can also raise a case through the courts, or raise a claim through the courts. So this is a case where this well-known TV personality made a subject access request, and they complained about the redactions being overly heavy. essentially that they didn't comply with the subject access request to the extent that they should have done. So the individual has raised a claim in the court seeking £10,000 in damages plus interest on top of that. I'm not sure of the outcome of that yet, and it may well still be ongoing, but it just highlights the point that individuals can go down another route if they are that way minded and can afford to do that. So it's just, again, thinking about how you handle those SARs as soon as they come into the door. They need to be handled quickly. You need to be transparent with the individuals, particularly if it's a high risk contentious case. This is where it all gets very emotional and difficult, and the context, depending on the context. And you need to treat every SAR as though the individual will go to either the ICO or potentially through the court. So documenting decision making as well, what exemptions were applied. And that's why organizations should have a DSAR or a data subject request register, so you can keep a record of all your requests and how you've handled them.
I think it's also worth just quickly pointing out that this taking you to court for compensation is completely separate and not dependent in any way on anything the ICO may or may not do. So, you could conceivably, I mean, I think it's unlikely, but you could conceivably wind up getting an enforcement notice and or a fine, and the individual could still take you to court for compensation. So quite apart from any costs incurred in complying with the notice or any costs incurred as a result of a fine, there is that sort of second avenue where you might incur costs as a result of the individual effectively suing you, I guess, for want of a better word, in court for that. So yeah, and I think I just want to reiterate that documentation point as well, because it cuts across everything we've talked about today. When you're making these difficult decisions, and like I said, we're here to help you make those decisions, but you will always hear us say, keep a record. Be able to show you're working out, because if you can show you're working out, the ICO can disagree with you and tell you to do something different, but you're far less likely to end up going down the enforcement route with them.
Yeah, absolutely. Yeah, so and I know the team put together multiple case studies and some brilliant examples. We only had sort of space for 3 today, but I think that they all provide a real sort of broad and interesting context. And I think so much of it again comes back to how these subject access requests are managed in the initial sort of reception and triage phase, and if it's not managed well at that point, things are far more likely to go south and become messy and complex and lead to the sort of actions that we see in the case studies. So yeah, so that's us really. So I mean, yeah, if anyone has any questions now, or we can tackle them now, but absolutely feel free to contact us. You have all of our contact details because we work with you directly as clients. Just ask some questions on the back of the session. As I said at the beginning of the masterclass today, that the session has been recorded and the recording will be shared with all of our clients. And again, from that, if that raises any sort of concerns or questions, please feel free to reach out to your point of contact within our team. I don't think we have any questions in the chat.
No, there's nothing in the chat. No, radio silence.
Brilliant. That's great. So yeah, I take that good or bad. So all it leaves me to say is thank you, as always, to Megan and Ian for fantastic insights and knowledge and expertise. It's really invaluable. Thanks to everyone that's attended, and hope to speak to you all again soon. Take care.